For all verified facts, subscribe to our YouTube channel and click the bell icon to get the latest updates.
Hello and welcome. The concept of freedom of speech goes back a long way, maybe to the Roman Republic, as some would say. The Universal Declaration of Human Rights in 1948 also talks about the freedom of speech. The freedom of speech and expression go together. Perhaps the freedom of speech, expression and media freedom are linked, but perhaps not so directly. So what does freedom of speech exactly mean, and more so in a country like India where we are right now? At this point, has it ever changed? Have certain judgments, in this case by the Supreme Court of India, changed the way we look at freedom of speech or ought to look at freedom of speech? Let's try and understand that a little better. But by looking at what the Constitution says, what are the exceptions which were always there, and to that extent, do we as a country really enjoy freedom of speech as we would like? And even if we were to exercise freedom of speech as we would like to, what are the safeguards that we should perhaps impose on ourselves, or should we not impose any safeguards? So that's really the question I'm posing, and who better to pose it to than Supreme Court lawyer Prashant Bhushan. Mr. Bhushan, thank you very much for being with us today. So tell me, before I mean, you've been in a very, very famous case which has ended with the Supreme Court convicting you for contempt of court, which in turn links to the freedom of speech concept, and we'll come to that, for which you had to pay a fine of ₹1 or face imprisonment, and you have paid the fine of ₹1, and you have now said that you will appeal against that. So let's come back to the primary question first. What is freedom of speech?
So freedom of speech is the right to say what you want freely. That's the freedom of speech, and that's a protected fundamental right under our constitution, because in any democracy, it is important that every citizen should be able to speak his mind freely, so as to be able to say what he wants, what he needs, what in his view is going right or wrong in our society, what in his view the government is doing which it should not be doing, what is it that the government should be doing, or what is it that any public authority should be doing, what is it that any institution is doing which is not right. So all these are parts of freedom of speech which are required in any democracy, because a democracy means that society is governed by the rule of law and by the rule of the people, the law created by the people in the way that the people want. And you can't do that unless the people are able to discuss freely what is it that they want, what do they feel about what is going on. And that is why all this freedom of speech was made into a fundamental right, and perhaps the most important fundamental right in any democracy.
And how does this right flow from our constitution? I mean, what is the relevant statute, and are there any provisos or exceptions?
Yes, so under Article 19(2), the freedom of speech can be restricted by way of reasonable restrictions imposed by law. So the key words are reasonable restrictions, second, imposed by law, and thirdly, in the interest of sovereignty and integrity of India, security of the state, foreign friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. So the reasonable restrictions on the freedom of speech can be imposed by law, but those must be reasonable and they must be relatable to the things which I just mentioned. That is security, integrity, friendly relations, public order, decency, morality, contempt of court, defamation. These are the only grounds on which freedom of speech can be restricted, but only reasonably restricted.
Right. So therefore, freedom of speech is not an absolute. It's not an absolute. even in India?
No, it's not an absolute. It's not an absolute. For example, yeah, go ahead.
No, so I mean, I'll come back to this in a moment, but how would you compare it with other democracies, let's say Western democracies, maybe Scandinavia, European democracies, North America? I mean, are there any comparisons? I mean, do they have similar, let's say, provisos or exceptions to freedom of speech?
So probably the US has the most expansive freedom of speech law, where restrictions are, so for example, in that Pentagon Papers case where the New York Times published the Pentagon Papers, which revealed a lot of defense secrets during the war, etc., during the Vietnam War. The court held that even that, and the government tried to restrict it on the ground of security of the state, etc., etc. But the court, the U.S. Supreme Court, held that no, that cannot be restricted because even about what is going on by way of what the government is doing by way of the security of the country, that also needs to be known to the people, that needs to be freely discussed. So, see, in India, this has been attempted, freedom of speech has been attempted to be restricted or stifled by use of the sedition law, which is part of the penal code, which says that if you do something which brings into disaffection the government or creates disaffection against the government of the day, then it says whoever by words either spoken or written or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punishable. So the question arose because the law of sedition, this is a colonial law, this was made by the British government, it was a pre-constitution law, and it was still being used even after the constitution. It was being used to prosecute people who were speaking against the government, who were criticizing the government, etc. And therefore, this question arose as to whether this law, as it is literally worded, that attempt to create disaffection against the government, whether such a law can be considered to be a reasonable restriction in the interest of the security of the state. And the court held in 1962 in that Kedarnath case that no, it cannot be said to be a reasonable restriction unless you interpret it differently, unless you say that sedition offense will only be committed if you are trying to overthrow the government by violent means or by creating public disorder. So they restricted the meaning, but unfortunately even today, because the law as it read is still on the statute book, so there are a lot of governments and a lot of police authorities which are still continuing to misuse it to charge people who are merely criticizing the government, which is clearly a fundamental right.
Right. So you're saying that it's only the law, the sedition law, when read with freedom of speech, which causes the problem. So if the law against sedition was not there, then the freedom of speech law that we have or the clauses that we have are fine?
No, I'm not saying that. So another instance arose when the 66A of the Information Technology Act was tested. Because the Act says that anything which is indecent or causes alarm to people or which is grossly offensive, etc., without defining any of these things, is an offense under the Information Technology Act. And the court said that, look, this is too vague and undefined. And there were a lot of people who were being charged under this provision of the Information Technology Act just because they were posting something which was highly critical of another individual. which that individual said was causing him alarm or causing him that was indecent towards him. And therefore, the court struck it down, saying that this was too vague and therefore does not constitute a reasonable restriction in the interest of either public order or decency or morality. Same thing we tried to do in this when we challenged this contempt of court, a part of it, that is scandalizing the court or lowering the authority of the court. You see, contempt of court is civil contempt or criminal contempt. And even in civil contempt means disobeying a court order. Criminal contempt is also in two parts. That is interfering with court proceedings or with the administration of justice. So that is not a problem. But the other part, scandalizing the court or lowering the authority of the court, we challenge it on the ground that this is also very vague and undefined. And because, go ahead.
Sorry. So let me come back to, so there is freedom of speech, there is freedom of expression, and there is press freedom. Now, are all three interlinked, and do they flow from the same clause 2 of Article 19 that you spoke of, or are there now, does sort of media freedom differ, as in you mentioned, you talked about state security, public order, decency and morality. Do the same provisos apply to media as well?
Yes. Freedom of speech of any individual or the media. Media has the same rights of freedom of speech as any individual. And therefore, the rights of the media to speak can be restricted in the same way for the same reasons as any individual. However, today the difference between media and individual has been obliterated because with the advent of social media, every individual exercising his freedom of speech. So, for example, my tweets are in a way my personal expression of opinion, but because they are being expressed through the social media, it also involves the right of the media to speak. So the right is exactly the same. The restrictions are exactly the same, whether they are on any individual or whether they are on the media.
Right. Is freedom of speech the same as freedom of expression? For instance, artists and performers, creative expressions?
Yes, they are the same. So some people say that, you should have absolute freedom even in the social media to say anything that you want. That's not really correct because, for example, under the Indian Penal Code, spreading hatred between communities on religious or other sectarian grounds is an offense. And that would constitute a reasonable restriction on the basis of public order, because if you are trying to spread hatred, then you are clearly giving a signal to people to take the law in their own hands and create public disorder. So, so that can be restricted. But as I said, the restrictions have to be reasonable restrictions.
Right. Now let's come to contempt of court. So when does is a freedom of speech violation, so to speak, how does it and when does it lead to contempt of court? Is it is it only because someone like you may be an officer of the court or someone who is practicing in court, or is it something that can apply to me too?
No, it applies to everybody. There's no distinction, just as there is no distinction between the rights of an individual and that of the media regarding freedom of speech. There is no distinction between the rights of a lawyer or an officer of court or a retired judge or a sitting judge vis-a-vis any other ordinary citizen. Everybody has the same rights. So, so as I said, that there are two parts of contempt of court: civil contempt, which is disobedience of a court's order that has nothing to do with speech, then criminal contempt, which is again in two parts, interfering with court proceedings or interfering with the administration of justice. That also usually has nothing to do with speech. It's the third part, which is scandalizing the court or lowering the authority of the court. That offense under the Contempt of Courts Act is usually committed by speech. And it is if you say something which is which is against the court or against some judge, then that can be treated. You see, this is not defined anywhere, what is scandalizing and what is lowering the authority of the court. And that is why we had challenged this provision on the same ground on which 66A of the Information Technology Act was challenged and struck down, that it's very vague and undefined. And also because this is a jurisdiction which is exercised by judges in their own cause, where they are sitting as the accuser. So if you say something like, for example, I said that the Supreme Court has failed to protect democracy in the last 6 years, and that the role of the last 4 Chief Justices has been crucial in failing to protect democracy. Now, then I was accused of contempt of court by the same Supreme Court whose judges, or some of whose judges would be the same, or many of whose judges would be the same, which I was criticizing. As I said, every individual in a democracy has the right to criticize any institution. Therefore, if you try and make a law which restricts or makes it an offense to criticize even the court, that should be deemed to be an unreasonable restriction on the freedom of speech. You can restrict freedom of speech even on the ground of contempt of court, but not unreasonably. Therefore,
right. So I mean, again, to a student, let's say, of political science, this would, to me, it would seem that because it's not defined, it could work both ways. It could work in the court's favor if it were to take a stringent position on a certain issue, and it can work in your favor if you're trying to argue it out.
Yeah, but if it is not defined, you see, the citizen is not aware of what he can do and what he can't do. And that makes it unreasonable. If you want to impose reasonable restrictions on the freedom of speech, the citizen must know what those restrictions are. And if it is so vague and undefined, as 66A was of the Information Technology Act, or as this scandalizing or lowering the authority is, then that's an unreasonable restriction.
Right. So then how does one address that? I mean, so let's say we are at this impasse of sorts because there are certain interpretations of reasonable application which are left open, and it could be interpreted either ways. So then is it not incumbent on someone to then define it? And then how does one do that?
Yes, so that's why we went to court saying that either you strike it down or you read it down. In 66A of the Information Technology Act was struck down on the ground that it's too vague and undefined. What constitutes annoyance to somebody or not? I mean, you have a right to criticize an individual, especially an individual who is in public life. So, and if he says, no, this is causing me annoyance, and therefore it's an offense, and he registers an FIR, so that was considered to be unreasonable because it was too vague and undefined. Same thing about scandalizing. It needs to be either defined or it needs to be struck down. It needs to be very, very clearly defined so that people know exactly what is permissible. Suppose they say, if you accuse any judge of being corrupt, or giving judgments for extraneous considerations, then that would constitute scandalizing the court. That one can understand. Of course, even there, truth is a defense. Under the Contempt of Courts Act, an amendment was made by which truth has been made a defense. Not only that, you cannot punish somebody for contempt of court, unless it has substantially interfered with court proceedings or with the administration of justice. So therefore, strictly speaking, normally, speech by itself should not constitute a punishable offense under the Contempt of Courts Act.
Right. So, no, I mean, let me come back to the same question. So, if I'm trying to say or ask, why is my country, whether it's the executive or judiciary, not defining what is a reasonable boundary for freedom of speech? So, who do I pose that question to?
So, it has to be posed to either to the legislature which made these laws, or it has to be posed to the court.
So, last question. So, does all of this, including the case that you've just gone through, does that change the concept of freedom of speech as defined by Article 19?
Yeah, in my case, the judgment is very bad in the sense that it holds that even these tweets amount to scandalizing and therefore contempt. And therefore, they have said basically that any criticism of the court amounts to contempt of court. It's a very bad judgment. We are challenging it by way of review as well as filing a writ petition, etc. And we hope that it will be overturned and that it will not become a precedent which can be used in other cases.
But it need not be a precedent outside of this particular case. I mean, for instance, this is contempt of court in the courtroom, so to speak, or concerning people who are working with the court or officers of the court or judges. But let's say a normal person, a citizen, or maybe a media person says something, as they do every day, no one, I mean, nothing happens to them, for one. And second, they do not seem to be maybe causing the same amount of, let's say, trouble as maybe you did.
Yeah, I mean, the law is the same for everybody, so they could charge any media person or any ordinary citizen also for saying those kind of things, or anything for that matter which is critical of the court. They picked upon me possibly because they thought that what I say is heard carefully and seriously by a lot of people, and therefore they felt that the damage that what I was saying was doing to them was far greater than the damage which any ordinary person or any media person saying would do to them.
Right. So therefore, to come back, I mean, so the freedom of speech as a concept in this country, therefore, is not really affected. I mean, except in the kind of cases that you've defined, given that we already have exceptions and provisos.
Yeah. Yeah. So there are still, as I said, gray areas in the law which need to be sorted out, especially in relation to this scandalizing the court or lowering the authority of the court. Fortunately, they sorted it out in the case of sedition. But even that, as I said, because the law still reads the same, that creating disaffection against the government is sedition. And therefore, people who are criticizing the government or the Prime Minister, etc., are being charged with sedition. Though the Supreme Court had said that unless you are saying something to create public disorder or violence, then it will not be sedition. But unfortunately, that judgment is being ignored. There are still people who are being charged under 66A of the Information Technology Act, even though that has been struck down. A lot of police officers, etc., don't know as to what is the interpretation given by the Supreme Court, what has been the development of the law.
Right. Yeah. And that's something that one shall pick up at a later date. Mr. Bhushan, thank you so much for joining us and providing your insights on what really freedom of speech means and means to me. Thank you.